Hello everyone, welcome to my channel. Don't forget to like, comment, and subscribe. Vermont Supreme Court revives COVID-19 business interruption insurance claim. The Vermont Supreme Court has kept alive a COVID-19 business interruption loss claim by major shipbuilder against a group of reinsurers. The state's High Court ruled that the case brought by Huntington Ingalls Industries and its captive insurer should proceed, although the justice stopped short of endorsing Huntington's claim that the COVID-19 virus caused direct physical loss or damage to its property that should trigger business interruption coverage. Huntington has argued that the virus adheres to surfaces and creates a condition requiring sanitation procedures, redesigning spaces, installing barriers, and other mitigation steps, thereby triggering businesses interruption coverage in a commercial property policy. The trial court concluded that the complaint didn't allege facts that would trigger coverage under the policy and granted judgment on the pleadings in favor of the reinsurers. But the state Supreme Court by a 3-2 votes has remanded the case back to the trial court. Supreme Court Associate Justice Harold Eaton Jr. wrote that Huntington had managed to meet the state's law hurdle for pleadings in alleging that the virus adheres to surfaces and causes physical damage. To be clear, this opinion doesn't state that what occurred in insured shipyard is direct physical loss or damage to property under the policy. We merely conclude that insured has alleged enough to survive a Rule 12 motion under our extreme. Eaton wrote, the ruling sets Vermont apart from other states. State High Court in South Carolina, Iowa, Massachusetts, and Wisconsin, as well as all of the regional U.S. Circuit Court of Appeal, have all ruled that the virus that caused COVID-19 cannot cause a direct physical damage or loss covered by a commercial property insurance policy. The shipbuilder's complaint alleges the pandemic caused direct physical loss or damage to property when the virus adhered to surfaces for several days and lingered in the air for several hours at the shipbuilding yard. The alleged losses include disruption in orderly construction and repair of vessels, schedule impact in the construction and repair of vessels, expenses, including increased labor and information technology costs, incurred to continue as near to normal operation as practicable, loss of profit caused by the change in labor volume and other time element losses. Reinsurers argue that their policies unambiguously require some tangible harm to the property or that the property be physical loss due to an external physical force. They also argue that insured mitigation argument is only relevant if coverage under the policy is triggered, which they contend it was not in this case. The High Court found that Huntington had adequately alleged that the virus physically altered property in its shipyard when it's adhered to surfaces. Moreover, the fact that the insured had to physically alter its property in certain ways bolsters the argument that a distinct demonstrable physical alteration occurred and is something that is in need of repair to restore business operation. The Vermont Supreme Court opinion notes that the insured may not be able to prove that its losses stem from direct physical loss or damage to property, and reinsurers may well be correct that the insured losses were not caused by any direct physical loss or damage to property, but instead from the risk employees posed to each other or some other non-covered reason. However, we cannot agree that it is an obvious fact that undermines the various allegations in the complaint, which at this stage we must accept as true. Thanks for watching, see you in the next video, and bye bye.